fraternity woke up to the demise of Fali S Nariman on February 21, 2024. A man known for his impeccable contribution to the Indian judicial history held an illustrious career spanning across 6 decades. Fali S Nariman was born to Parsi parents in Rangoon in the present-day Myanmar. The attacks on Burma by the Japanese became a responsible factor for a 12-year-old Nariman to leave his homeland with his family and come to New Delhi. Upon completion of legal education from Government Law College, Bombay, he joined the chambers of Sir J.B. Kanga. A major turning point in his career was the appointment as a senior advocate in the Supreme Court of India in 1971. He was the additional Solicitor General between May 1972 and June 1975. He has also served as the President of Bar Association between 1991 and 2010. Beyond the walls of court, he was nominated as a Rajya Sabha member from 1999 to 2005. For making integral changes to law and society, he became recipient of several accolades: Padma Bhushan in 1991, Gruber Prize for Justice in 2002, and Padma Vibhushan in 2007. The legal career of Fali S Nariman is one of conviction and conscience. Let's take a look at few of the legal battles that led Nariman along this bold journey. Golaknath versus State of Punjab. A family in Jalandhar, Punjab had owned 500 acres of farmland. The Punjab government passed a law in 1953 by which a person was only allowed to hold 30 acres of land. The Golaknath family challenged this law because it violated their right to property, right to practice profession, and right to equality. They also challenged the 17th Amendment to the Indian Constitution, which permitted the Punjab government to pass such a law. Nariman was a junior counsel in this case for the Golaknath family. This case is considered significant for putting forward a daring statement that Parliament cannot be allowed to make amendments to Part 3 of the Constitution that dealt with fundamental rights. It is also regarded that this case laid down the basis for the basic structure doctrine. Nariman was a firm believer of a rights-based approach and spoke unflinchingly against arbitrary government interference. Minerva Mills case. Minerva Mills was a textile industry situated in Karnataka that mass-produced silk garments. It was doubted that the mills met the requirements of a silk industry. In pursuance of this, in 1971, the central government directed the National Textile Corporation to take over the operation of Minerva Mills based on a committee recommendation. This action was challenged by Minerva Mills. Nariman was one of the counsels for the petitioner. The Supreme Court decided that the amending power of a parliament cannot be employed to abrogate the Constitution itself, as well as the fundamental rights and the directive principles of state policy must have a congruence between them. Nariman attached profound importance in balancing these two entities, which was unnecessarily portrayed as contesting themes. The Bhopal gas tragedy case. In 1984, at Bhopal, 42 tons of toxic chemicals leaked from a pesticide plant owned by Union Carbide India Limited, resulting in death, environmental damage, disability, and genetic implication on the people residing near the plant. In 1988, the Supreme Court heard the case for compensation of the victims. In this case, Nariman represented the Union Carbide Corporation and its American directors. The Supreme Court decided this case by directing the Union Carbide Corporation to pay $470 million in settlement to the victims. Nariman received harsh criticism for defending the culprits in one of the worst industrial tragedies in India. Later in 2010, for a curative petition filed by the former MD of the Union Carbide Corporation, Nariman was offered to lead this petition, and it is reported that he refused it. As a stalwart of judicial independence, Nariman associated himself with all major cases that curtailed or questioned it. Until 1981, the appointment of judges was carried out by the President upon consultation with the Chief Justice of India. In S.P. Gupta v. Union of India, popularly known as the first judge's case, it was inquired whether the term consultation meant concurrence. It was decided by the Supreme Court that executive has primacy in matters of appointment of judges, and the opinion given by the Chief Justice of India can be refused for cogent reasons. This decision sent shockwaves among the law community because the very basis of the independence of judiciary was at immense risk. The second judge's case. This was a challenge against the first judge's case of 1981. Nariman was one of the counsels for petitioners and argued that to protect the independence of judiciary, advice given by the Chief Justice of India must be binding, because judges are better positioned to determine suitability and competence of candidates. The Supreme Court established the collegium system in this case. This was a huge leap in an attempt to separate judiciary from politics. The third judge's case. This wasn't a case per se, but it was a reference made by the then President K.R. Narayanan to the Supreme Court, clarifying the procedure for appointment of judges following the second judge's case. In this hearing, Nariman made submission in elucidation of points of law and assisted the court to reach a decision. This case made changes to the collegium system by increasing the number of judges. The fourth judge's case. An important event in the constitutional history happened in 2014 when the Parliament passed the 99th Amendment to the Indian Constitution. The purpose of this amendment was to replace the collegium system with the National Judicial Appointments Commission. Nariman appeared in this case and answered the court that his client was independence of judiciary. He vehemently opposed the attempt of government to tamper with judicial process that had distanced itself from political gimmicks through the second judge's case. The Supreme Court of India struck down the NJAC, stating reasons that this amendment violates separation of powers and independence of judiciary, which are foundational values of the Indian Constitution. The Kaveri water dispute. Kaveri River is an interstate basin that originates from Karnataka and passes through Tamil Nadu before draining into the Bay of Bengal. The sharing of water between the states has been a bone of contention for decades. Nariman has been the legal consultant for the state of Karnataka for over 32 years in this dispute. His association with the case became a pivotal reason for the Supreme Court decision on deciding the quantity of water that both states are eligible to receive. In honor and respect of this long-standing relationship between Nariman and Karnataka, the Hindu reports that the Karnataka was planning to name an irrigation channel after Fali S Nariman. These are only a handful of cases that adorned his established career, for which he truly stands as a guiding figure for budding advocates in the legal community. Apart from his role as an advocate, he involved deeply in the political environment of India, adopting and voicing an outlook that was feared by most during his time. Nariman became an additional Solicitor General in May 1972, which was a crucial development in his career. However, He resigned from this position in 1975 when Indira Gandhi imposed national emergency. This resignation was his message of dissent with the Indira Gandhi regime. It was reported that he affirmed to never take up any government posts in the future. In 1998, Nariman was approached by the state of Gujarat seeking his representation in a case relating the Narmada Dam project. During this time, the news of widespread violence against Christians were reported from Gujarat, which was alleged to be facilitated by the government. Although Nariman clarified this atrocity, the government refused to respond. Nariman swiftly returned the case brief to Gujarat and showed his displeasure in representing them. The unanimous judgment of the Supreme Court on the constitutionality of Article 370 deeply disturbed Nariman for the lack of dissenting opinion among the judges. He, however, agreed with the integration of Jammu and Kashmir from a political standpoint. His persuasive reminder of the strength of a judicial system reflected in his opinion across the years. His passing marks the end of an era with persistent contribution to Indian and international law, which will remain a beacon of distinction and uprightness. If any of you may be interested to learn more about the life of Fali S Nariman, his autobiography is available for purchase on leading platforms titled Before Memory Fades.